The other night at a candidate forum, one of my opponents, Nancy LaCour, said that the Equal Rights Amendment was unnecessary. Now, she cited the preamble to the Constitution, "We the people," as proof that women are already protected under the law equally. I have to be honest with you, that argument is absurd. It's not a Democratic argument. In fact, it's a Republican argument. It's the same argument that's been used to oppose the Equal Rights Amendment for decades. And the fact that a Democratic candidate for Congress is making it should give every voter in this primary serious pause. You want to know if women are already protected equally under the Constitution? Ask a woman in South Carolina who makes 85 cents for every dollar a man makes for doing the same job. Ask a woman navigating a healthcare system where the protections against sex-based discrimination are just one congressional vote or one court decision or one executive order away from disappearing. Because without the ERA, there is no constitutional floor protecting them. Ask her if we don't need the Equal Rights Amendment. And here's why that argument fails on the law. "We the people" is in the preamble to the Constitution. Courts do not enforce the preamble. You cannot walk into a federal courthouse and cite it to win a discrimination case. It carries no operative legal force whatsoever. That's not a matter of opinion. It's not a matter of interpretation. That is black letter constitutional law. So where do we actually look? The 14th Amendment, which does guarantee equal protection under the law, has been used by Republicans to say that that's why we don't need the ERA. But here's what they fail to understand. Courts have never interpreted that clause to give sex-based discrimination the same standard of judicial scrutiny as race-based discrimination, for example. Sex discrimination gets a much lower standard or an intermediate standard, which means that discriminatory challenges are less likely to survive in court. That means more discrimination goes unchecked. And the Equal Rights Amendment fixes that. It raises the constitutional floor. This means equality in pay, equality in healthcare, equality in education. And yes, it lays the groundwork for reproductive rights, because when courts will be forced to apply the highest standard of judicial review, the laws that discriminate against women, those laws are far less likely to survive. Legislation can be repealed, legislation can be struck down, a constitutional protection cannot, not without going through the amendment process itself. Now, Virginia was the 38th state to ratify the ERA. So in my opinion, the threshold's been met. And in Congress, I will fight to force the federal government to recognize that ratification and direct the archivist to record it. South Carolina needs someone who knows the law, who's ready for this fight, and is ready to win it. I'm Mac DeFord. I'm running for Congress in South Carolina's 1st District, and this is what it will look like when you send me to Congress to fight for you.